All right, thank you very much for that welcome. And so I'm going to be talking about my my book. This book originally came out this past August, and we started doing a Rotary tour, and COVID kind of put a kibosh on it. But anyway, I'm glad we're able to visit here with the club. Let me go ahead and get started on this. So first of all, why does it matter what I'm about to tell you, what you're about to learn? Well, one, I'm board certified. I've been in practice for over 23 years. It's going to be 25 years in November. I've been a mediator since, somebody else took over the screen. Here, sorry about that. Let me reshare my screen. All right, so I've been a mediator since 2003, and I've got three degrees in here that Armengol has already gone ahead and mentioned. So let's jump right into what we're talking about with asset protection. So the first thing is you need to know what is your risk exposure. What are you in a risk zone? Are your assets already protected? What kind of risks are you exposed to? So the first thing is, what kind of risk? So the first kind of risk is, personal liabilities, auto accidents. Okay, you see those guys on TV, the 222s, the 444s, the hammers, all of those guys. My neighbor down the block, the people on the buses, they're looking for auto accidents. They're also looking for property liability. If somebody falls at your house, who here has dinner parties where they invite people over to their house, who serves wine and have a good time? So if somebody gets hurt, yeah, exactly, right here. If somebody gets hurt, you could be liable for that. So you want to make sure you've got your personal liability protected. Another thing that's important is contract liability. Okay, so a quick show of hands. How many of you have read your entire cell phone contract? Okay, I never get anybody raising their hands about that. I'm actually still waiting for a client to be willing to pay me to read through it, so I at least know what my contract says. So you could have some contractual liability that you haven't really looked at, and you're not really completely aware of what contract liability. Now, you also can have risk exposure from other people. Okay, so this is where slowly we start losing control of what our risk pool is. So if you own a business, your employees can create a risk. If your receptionist runs down to go pick up Urban Brick for lunch and is in a fender bender, you could be liable for that. Who has kids that are old enough to drive? I have a few of them. Who has kids that drive cars that are titled in your name? So you're at risk. If they're in an accident, you could be liable for that. If you are in a business and you have business partners, your business partners could obligate you to do certain things or to pay certain bills that maybe you aren't expecting, or they could create liabilities through contracts that could also put you on the hook to pay that bill. So let's jump into discovering the 3-bucket method. Okay, I love this quote: "Success occurs when opportunity meets preparation." That's by Zig Ziglar. So when we're prepared and there's an opportunity, we're ready to react to it. The same goes with whenever a risk appears. If we've prepared ourselves, we'll be able to get through it with the least amount of pain. So if you've got your assets protected, you're going to be in a good position. So Now, without further ado, let's jump into what the three buckets are. So let's start with the first bucket. So the first bucket is what I call the moving parts bucket. Now, in the moving parts bucket, here's where you have your professional practices. You have your operating businesses that own equipment, that have employees. So when you have a business like this, it is high risk. If you have employees, they could create problems that you as the business owner are responsible for. So it's important to have the right type of business entity. So if you're a sole proprietor, you and the business are the same, and there's no difference in the risk that you have. If you have an LLC or a corporation, or even a limited partnership, the owners are separated from the business. So the business is the one that takes the hit. So that's one part of the equation. The other part is you may have multiple businesses here. So if you have, for example, a trucking business, you may want to actually look at three entities in this moving parts bucket. You want to have maybe one LLC that has operating authority. You have another LLC that owns your tractors, and another LLC that owns the trailers. So you've got those three different entities separated out. I use trucking as an example because it is also a highly litigious area, and it's very common here in Laredo. We can all kind of relate to that. So you want to make sure you have a separate entity for each line of business. One of the questions I get quite a bit is, Mike, can I do more than one type of business out of my LLC? And I tell them, you're asking the wrong question. The right question isn't can I, is should I? So if I have a trucking company and I have a food truck business, they're both trucks, right? So I can put them in the same LLC? Well, you can put them in the same LLC, but should you? You really shouldn't. You want to separate those risks. You want the food truck to be separated so that if somebody gets sick from your food, they can't shut down your trucking business. And if one of your drivers crashes, you don't want it to shut down your food truck business. So you want to keep those separate. They're all in the same bucket, but they're all separated by layers in your using LLCs for every line of business. So that brings us to bucket number 2, the dirt bucket. So the dirt bucket, as the name implies, is where you hold real estate. Now this can be raw land, rental properties, that rental properties could be residential rentals or commercial rentals. It might even be the business real estate. So let's stick with the trucking business. So the warehouse and yard that they operate out of should not be owned by the company or by the individual. It should be owned by a separate LLC that just owns that real estate. So you want to keep properties separated. I never tell my clients what to do. I only advise them what their risks are, what the liabilities are, and allow them to make a business decision. My personal preference is not to have more than $500,000 of aggregate property in one single LLC, or if you have one property that is fairly large, you want to make sure that it is in its own separate LLC. There's no point in making multiple LLCs to own something over $500,000. So here's an example of the importance of separating. So let's say you've got a ranch that's worth $2 million and you have a little rental condo in town that's worth $50,000. If you put those two in the same LLC and your tenant hurts themselves on the property, they could potentially own your ranch if they're able to get a judgment in that amount. So as you can see, putting those layers is extremely important. So here's the 2 buckets so far. Now we'll go on to the 3rd bucket. So The third bucket is the paper bucket. Okay, so what does this talk about? The paper bucket is where you would put excess cash. So if your business is generating excess cash, you want to move it into this paper bucket. You want to move brokerage accounts. You want to title them in the name of this paper bucket entity. You want to have ownerships in the other businesses to the extent possible. So your trucking company could be owned by your paper bucket company. And your dirt bucket company could also be owned by this one. And so I know what everybody's thinking. Mike, you just finished telling us everything needs to be separate. We need to be OCD about the carrots not touching the peas and the chicken not touching the mashed potatoes. Keep everything separate, and now you're just dumping it all together. Okay, so here's an important time to talk about what does that mean in the paper bucket. In the paper bucket, we're talking about certain types of risk. In the other two buckets, we have a different type of risk. So it's internal risk and external risk. The internal risk, like we alluded to in the moving parts and paper bucket entities, is the risk that grows from what's inside the company. So your tractors could hurt somebody. Your drivers, your employees could create a problem that the company will be liable for. So that internal risk is one that's important to mitigate. In the paper bucket, the internal risk is eliminated because all you own is paper assets. So they don't have a risk to them. If you owned Apple stock and Apple were to get sued, you would never worry about, oh man, I'm gonna have to pull money out of my accounts to pay this judgment. No, your just the value of your portfolio would go down. It's the same thing with the paper bucket. It's kind of like your personal mutual fund that owns your paper assets. So that's how this is protected. Now, this also protects you individually from lawsuits in that if you are sued personally and they try to collect a judgment from you and they try to take your shares, with an LLC or a limited partnership, the only thing they can do is get a charging order from the court. That charging order is an order that says, hey, LLC, if you make a distribution to Mike Dickerson, you need to make it to this person who has a judgment. Since we're all family, we're all in control, we don't make distributions. At the end of the year, instead of giving me a K-1, we give it to the person with a charging order, and now they get to pay the taxes that are generated from my companies. So the likelihood that somebody's going to want to continue paying my taxes for an extended period of time is very limited. Okay, so let's see, how does this work in the real world? Okay, so what could go wrong if we don't use the three buckets? Okay, what are we really talking about? So in a lawsuit, they could pierce a corporate veil. So you could lose your corporate status. And corporate, I'm using it in a generic way. If you're an LLC, you could lose they could pierce the veil of an LLC if you haven't maintained the assets properly. If you have allowed the businesses to be combined. For example, if one of the companies owns the real estate, and so you got your dirt bucket company, and then your moving parts bucket is the one that makes the money. And instead of paying rent to the dirt company, you just say, well, it's the money's in this account. Let me just write the check to the bank to pay for the mortgage payment. Well, you know, that you suddenly made a loan from one company to the other. And so who would lend me $10,000 without me having to sign any papers? Anybody? Anybody? No. Juanita, no? Nobody's raising their hands? Okay, so I'm still waiting for somebody to be willing to lend me $10,000 without signing anything. That's the exact thing that your plaintiff attorney is going to do in front of a jury. They're going to ask them if they would do that. And well, of course not. So basically, they're going to say we should treat these two companies like if they're really one. So now they've put your real estate in your moving parts bucket company, because we don't have that separation with a lease. With, you know, same thing. Would you let me stay at your house without paying rent, or would you let me move into your house without paying rent or having a contract? No. You want to have management agreements, and you don't have minutes. Minutes are the way that a business is able to talk. If there are no minutes, then there's no record of it approving these actions. So we're very familiar with it here with the, you know, with the way a board of directors works. It's the same thing with a company. Even if it's if you're the one person making all the decisions, you've got to document it for it to be effective. So we put it in place. What's the way that we get started? First thing is risk assessment and maintenance. So the first thing is you want to make sure you have a business structure assessment. You want to make sure that you've got your lines of business are all individually lined up with the right entity. You want to identify the business relationships between the different companies. So if one is holding the property and the other one is occupying it, you want to make sure you've got a lease agreement in place. You want to have separation of businesses into correct entity structures. You want to have those things separated, and you want to document those relationships. So you want to, you know, in law we say if you can't prove it, it didn't happen. So how do you prove it? Well, if you have a document, you have a lease agreement. Even if you're signing both sides of it, you have a lease agreement. So you have to have these documents in place to be able to prove you're not liable for those different things that could come up. Second is, what kind of entity structure should you have in each of these different buckets? Okay, in the moving parts buckets, a corporation or an LLC both would work very well there. In the dirt bucket, because there's certain tax implications, an LLC or a limited partnership, either of those two would work well in the dirt bucket. And in the paper bucket, likewise, an LLC or limited partnership, either of those two would be very appropriate structures to have in place there. So entity maintenance is one of the big solutions. If you have management contracts, management agreements, you want to make sure you document those in your minutes. So if the company is providing management services, should have it documented in their minutes. Hey, we entered into this agreement with company X that we are going to provide management services for X amount. The person receiving those services, likewise, should have an entry in their minutes saying, hey, we entered into agreement saying that company Y is going to provide us with management services. Same situation with loans, okay? So if you're paying things for another company or you're lending money, you want to make sure you have the document, but you also want to document it in your minutes. That's why, you know, minutes are very important. And I know we take these very seriously as part of our board of directors. This is going to be the way that you're going to be able to prove to the IRS that you entered into a loan, and not that they can create whatever illusion they want to get the most taxes out of you. If you lease or purchase equipment, you want to document that so you know when title has changed, so you know who has what liabilities, and you want to have a contract that says that. But then you want to document in your minutes what you have approved as far as what those different minutes are, what that's all about. Okay, so maintenance is entity minutes. So LLCs should, you want to make sure, like I said, that's the only way an LLC can talk, with minutes. A corporation must, by statute, they have to have an annual meeting at least no later than every 13 months. The minutes will document all the actions that were taken throughout the year. Whoops, sorry. The minutes will also confirm and approve the contracts that you've entered with other entities. So though that's a super important thing that is so hard for me to get clients to understand that it's really important. And unfortunately, we usually get calls when, hey, I'm having an IRS audit and I need my minutes up to date for at least the past 5 years. Or, hey, I'm in a lawsuit. Can you tell me can you put together minutes for the last 5 years? Yeah, we can put it together, but are you going to remember everything? What's the chances that we're going to miss something and they're going to say, oh, well, you didn't approve this particular thing, so we're not going to count it. So it's important that we stay on top of this at least every year to make sure that we've got those minutes done. Okay, so some to-dos on entity maintenance. Keep those up to date. Make sure they match your tax returns and your financial statements. You want to make sure your minutes are updated annually so you're not scrambling under the gun. You want to identify what's missing. Hey, did we lend money over here from one company to the other because there was just no time to properly move the money or document the move? Well, let's make sure we have those documents created. And we can help you accomplish those to-dos and make sure you're completely covered. Now, there's a few more things you need to know for asset protection. One is you need to act before something happens. If you move assets after you've received notice of a lawsuit or an audit, it could be considered a fraudulent transfer. You can be in a better position negotiating a settlement if your assets are already protected. So, for example, if you're an offender bender and one of the TV lawyers says, hey, I want $1 million for the whiplash my client got, and there's like not even a scuff on the bumper, you can say, well, look, do whatever you want, but if you want any more than the insurance is going to pay, you're going to get to pay my taxes for as long as you want to have that. So you're in a very strong position going in when you've been able to set up your asset protection. Your assets are already protected. Hey, deal with the insurance company because that's all you're going to be able to reach. So that's really, really helps you sleep well at night, knowing that you're protected and you're not at risk for things going wrong. Okay, so you also need to consider, do you have enough insurance? So the first thing that I hear sometimes from clients is, hey, Mike, now that I've got this asset protection in place, I can just get rid of insurance because I'm already have this bulletproof protection. Well, no, you want to make sure you keep your liability insurance in place. Why is that? Well, number one is we're all responsible for what we do. We want to make sure we're responsible that if something was our fault, if we caused a problem, we want to make sure we make it right. With insurance, there's a way to make it right without putting yourself at a major financial risk. Secondly, and near and dear to my heart, is somebody else will pay the attorney's fees if you're sued and you need to defend that lawsuit. Those attorneys are going to represent you on behalf of the insurance company, and you're aligned in that the insurance companies want to pay as little as possible on this claim. So they're going to want to defend you to not have to pay more than what is just right and equitable. Next, life insurance. Even though the estate tax has gone to $11.2 million, you want to make sure that that's there because we're in an election year and we don't know what's going to happen with the estate tax credit. So having life insurance in place is important for estate taxes, but it's also important to be able to take care of your loved ones if you're not there. The only thing we can leave is financial. You also want to make sure you have health insurance. I think right now in our current environment, we can really appreciate the importance of having health insurance. If we get sick and we're in the hospital, it could be a very serious dollar amount that we're facing. All right, and don't forget, you want to make sure you have the right plan in place to pass all of the assets that you've worked so hard in your life for. You want to make sure that you have a way to pass those on to your kids, to your family members. You know, we're recommending trust quite a bit more recently. They provide a lot more privacy. They avoid the expense of having to go through a court proceeding, and you know, trust can also keep your life insurance out of your estate for estate tax purposes. A trust can also be effective if you become incapacitated and your assets need to continue to be managed. It's a lot easier for your successor trustee to manage your assets through a trust than it is on a power of attorney. Sometimes banks don't want to recognize those and make you jump through a lot of hoops. And if we can't make changes to them to satisfy the banks, we're stuck. A will is a basic plan for protection to transfer your assets. It will still require going through the probate proceedings to transfer the assets. Then you also want to have powers and directives: power of attorney, medical power of attorney, healthcare directives, directive to physicians, designations of guardian. Those things you want to have in place. Even if you have all of this entity structure and everything is in place, you want to have these, because if you become incapacitated, that's how you're going to be able to manage that. A will, I'll just reiterate this, only works once you're dead. Power of attorney only works while you're alive and if you're incapacitated. So in a nutshell, you need to act before you have a lawsuit or an audit. You want to create the right entity structures that suit your needs, and you want to have sufficient insurance in place for responsibilities. You want to maintain your entity so that it will give you the protection, and you want to get legal advice from a board certified estate planning attorney. You want to make sure you have the right professionals giving you advice. There are a lot of street lamp attorneys that aren't really attorneys. It's my brother-in-law says that if I do this, then everything's okay. My cousin told me that nothing will happen because whatever. You get it from somebody who's a professional, somebody who does this for a living and handles this on a daily basis. It's so important to get the right information. There's a lot of myths, there's a lot of misconceptions out there. So please if you don't come with me, get with somebody who's a professional, who's going to be able to tell you what's correct. And with that, I thank you, and I'll be happy to answer any questions.
Awesome job, Mike. Thank you. It was awesome.
A question.
So I actually do have a question. I'm sorry.
Suggestion to